Good afternoon. Our next case is New Hanover County Board of Education versus Josh Stein et al. We will hear from the appellant.
Thank you, Mr. Chief Justice. May it please the Court. My name is Jim Doggett, and I represent the Attorney General in this case. With me here today is Blakely Hildebrand, who represents the interveners in this case, the North Carolina Coastal Federation and Sound Rivers. After I've completed my opening argument, Ms. Hildebrand will argue briefly for interveners for 2 minutes and discuss some of the benefits that the grant program has provided for North Carolina. I'd also like to reserve 5 minutes of my time for rebuttal. Your Honors, this is a case that should have ended long ago. More than a year ago, this court rejected the only claim that up until that time, the plaintiff in this case, the school board, had asserted, a claim that a grant program that the Attorney General had administered for nearly 20 years violated the civil penalty clause of the state constitution. Since that time, the board has decided to assert new claims, but it's made the unorthodox decision of, instead of filing a new lawsuit, of asserting those claims in this case while it was still on appeal. Most of the new claims that the board appears to assert are not properly preserved because they were not raised below while this case was on remand in the Court of Appeals. As a result, today I won't address those claims unless this court has questions about them. Instead, I'll address the one claim that the board did assert on remand in the Court of Appeals. It's claimed that a new statute enacted in 2019 required the funding for the grant program to be deposited into the state treasury. And while that claim was preserved below, the Court of Appeals nonetheless erred for 3 reasons when it granted the board relief on that claim. First, the board's complaint, which was drafted 3 years before the enactment of the 2019 statute, did not provide notice of a claim under that statute. Second, the board has also not shown that it has standing to assert its new claim. And third, the board's new claim is also moot and not ripe, because below, when the Court of Appeals erred, all of the funding that had been provided by Smithfield up until that point that was subject to the statute had already been deposited into the state treasury. And any 3 of these grounds provides a basis, a separate and independent basis for reversing the Court of Appeals. To begin addressing my first argument, the board's complaint does not state a claim under the new 2019 statute. This court has held repeatedly that to state a claim under statute and provide notice to a party of that claim, it's necessary for a party to allege facts that correspond to the essential elements of the claim. Here, to show that the board is entitled to relief under the 2019 statute, 2 allegations would have had to have been made in the complaint. First, that the Attorney General received state funds, and in fairness to them, that allegation is in the complaint. But the second allegation that needed to be there that isn't there is that there was a failure to deposit funds into the state treasury. And so it's really just, it's a simple application of this court's case law dating back to Sutton v. Duke back in the 1970s up to Estate of Savino more recently, that to state a claim and to provide notice of a claim, it's necessary to actually allege all the facts that correspond to the elements of the claim. And so it's really a quite simple argument, and as a result, the Court of Appeals erred below when it granted the board relief on a claim that it hadn't provided adequate notice to the Attorney General for. And it really isn't that surprising that they didn't make that allegation.
Let me jump in just a second. So would the Attorney General the Attorney General make a similar argument if the Court of Appeals had simply remanded to the trial court to allow the plaintiff to raise these issues and or amend his complaint in the trial court?
Well, a remand certainly would have been appropriate. In a situation like this, a party cannot amend their complaint unless they receive leave from the court to reopen the judgment that's already been entered. And here, that's what would have occurred because the judgment on the civil penalty claim had already been affirmed by this court. But certainly we don't think there's any res judicata bar for the board simply asserting these new claims in a new lawsuit that would have been filed, that could have been filed within weeks of this court's decision last year in April of 2020. So yes, it was inappropriate for the board, for the Court of Appeals to address this new unpleaded claim while it was on remand in the Court of Appeals. But there's nothing that would have stopped the board from doing what almost every other litigant would have done, which is simply to file a new lawsuit, and we wouldn't even be here today.
So it seems like the Court of Appeals used language from the majority opinion that at the very end of the opinion that says, remand this case to the Court of Appeals for any additional proceedings not inconsistent with this opinion. What is the, do you know what the usual interpretation of that language might be?
Well, I think the idea would be that the court cannot act inconsistently with the mandate that this court had provided when it remanded the case. But I think what that remand could have done, and if you look at the supplemental brief we filed in the Court of Appeals, we argued, first of all, we didn't know what our friends on the other side were going to argue in that brief, and so we argued that simply the enactment of the 2019 statute had not changed this court's ruling on the one claim that had been pleaded in the complaint, the civil penalty claim. So we pointed out that the fact that the funds would be deposited into the state treasury wouldn't change whether or not the funds were civil penalties or anything like that. And so basically what this court had done was to say if there's anything that the court needs to consider within the confines of the claims that have been asserted in this case that we can't do because the statute was enacted on the eve of oral argument, that was the work that was left to the Court of Appeals to do. But that certainly, a remand instruction cannot give a court authority to rule on a claim that hasn't even been pleaded in a complaint. Certainly not here where a claim, my friends here have also failed to show they have standing to assert a claim, and where the claim is also moot and unripe as well. Moving on to the second argument that we've made in our briefs about standing, the board also has not shown that it has standing to assert its new claim either. In this court's decision in Forrest earlier this year, this court clarified the rules that govern standing for statutory claims. It explained that in cases that involve statutory claims, there are two issues that courts need to address. Number one, whether or not a statute actually confers a cause of action. And then number two, if it does, whether or not the plaintiff has satisfied the statutory requirements for bringing suit that the General Assembly might impose for someone to assert a claim. And here, we don't even get to the second question because the board has not made any argument that the 2019 statute confers a cause of action. Instead, their argument seems to be, and they can correct me if I'm wrong, they seem to argue that the remedy clause of the state constitution confers standing on them to sue over an alleged statutory violation because they've suffered a legal injury. But in Forrest, this court was quite clear about what constitutes a legal injury. A legal injury doesn't exist within the meaning of the remedy clause unless there's also a cause of action. And that makes perfect sense because this court in Forrest clarified that it's really up to the General Assembly to decide who can sue over what violation of the statute. And so essentially what they're arguing is the General Assembly doesn't have that authority, that any statutory violation can be sued over regardless of whether or not a cause of action exists or not. And that's just not what this court held in Forrest, and the argument really doesn't make any sense either. So that's another independent reason. Not only does the complaint fail to state a claim, which isn't surprising, because it was drafted 3 years before the statute was enacted, and they had no reason to allege the central elements of their claims because they weren't relevant to asserting their new claim. They also lack standing to assert their claims. And then third and finally, their claim is also both moot and unripe. First, the claim is moot with respect to the past payments that Smithfield had made because when the Court of Appeals ruled below, those payments had already been deposited into the state treasury. And second, with respect to the payments that Smithfield had still yet to make, those payments were not yet due. So that claim certainly wasn't ripe either because there was nothing for the Attorney General to do in response to an order from the court. Nothing could be done. And this court has held, again, many times that when a claim depends on the existence of some future contingency where a party cannot act, a claim is simply not ripe. Just to provide one example, in Bacon v. Lee, this court addressed a claim, a challenge to the governor's exercise of his clemency authority. And with respect to certain of the plaintiffs in that case, they had not exhausted their ability to seek post-conviction relief. And there was a policy at the time that the governor simply would not rule on a clemency request at all until post-conviction relief had been exhausted. So the court held that with respect to those the claims raised by those plaintiffs, the case wasn't ripe because there was nothing for the attorney general to do. The governor to do, because he simply wasn't at a stage where he was ready to rule on those clemency applications. And here we have exactly the same thing, because the payments that Smithfield has made in the future are still due for Smithfield to make in the future under the agreement have not yet been made and aren't due yet. And so, respectfully, I think it's clear that the Court of Appeals simply in its haste, and again, this may just be, it's not something that was intentional. The Court of Appeals ruled on this case without oral argument. In the height of the pandemic, they simply didn't give this case enough attention and strangely ruled on a claim that had not been pleaded in a complaint, where there had been no demonstration of standing to assert the claim, and also where the claim was simply moot and unripe. It was moot as to past payments, and it was not yet ripe as to other payments.
I want to be sure I understood. So your argument is that after July 1, 2019, any funds that were received by the Attorney General have been paid into the state treasury?
That's correct. That's correct. Those payments have already been made. I don't think there's any dispute about that. They've been deposited into the state treasury, and since the Court of Appeals ruled, another payment has also been deposited into the state treasury. And again, we committed to see that those funds that under the statute should be paid, and the prior payments that have been paid, that have been made, have been deposited. The same thing is going to happen in the future. So unless this court has any further questions, I would turn things over to Ms. Hildebrand briefly to just talk a little bit about the practicalities of the benefits that the grant program has provided to North Carolinians. Thank you.
Good afternoon. May it please the court, my name is Blakely Hildebrand, and I represent Sound Rivers and the North Carolina Coastal Federation, the interveners in this case, and also recipients of grants under the Environmental Enhancement Grant Program. We respectfully ask that this court vacate the decision of the Court of Appeals and reinstate the trial court's grant of summary judgment in favor of the Attorney General. And to help this court understand the benefits of the grant program as this court decides this case, I would like to very briefly discuss some of the work that this grant program funds in our state. Along with dozens of other community and conservation organizations, Sound Rivers and the North Carolina Coastal Federation have used funds from the Environmental Enhancement Grant Program to enhance the environment and benefit communities throughout the state, as intended by the Smithfield Agreement. This program has been crucial to these organizations as they work to achieve their missions. Sound Rivers, which is based in Beaufort County, North Carolina, has been awarded several grants since the program's inception. And the organization used one of its earlier grants to design and implement stormwater best management practices, which significantly reduced flooding risks and cut down on pollution of the Tar River. And building on the success of that program, Sound Rivers applied for and received additional grants through this program to replicate and expand that work in several other counties and leverage those funds to acquire additional funding to expand the scope of this project. The Coastal Federation, which is based in Carteret County, has also received several grants since 2005 and has used grants for a number of projects, including funding, including conserving land in Carteret County, restoring habitats and hydrology on formerly agricultural lands in Hyde County, and installing living shorelines in several counties along the coast to enhance resilience of those communities. And Coastal Federation, along with Sound Rivers, have worked with several local partners, including municipalities and other local institutions and partners, to do this really important work on the ground. Grantees incur expenses and seek reimbursements on an ongoing and regular basis. And as such, the consistent and orderly administration of this program is crucial to these organizations and the contractors and partners with whom they work to implement these projects on the ground. So accordingly, we ask this court to reverse and vacate the decision of the Court of Appeals and reinstate the trial court's award of summary judgment in the Attorney General's favor. Thank you.
Thank you, counsel. We'll hear from the appellee.
Mr. Chief Justice, may it please the court. there's a lot at stake here. In the previous decision, about $12 million of state funds we lost. There's about another $12 million at stake here. My partner, Dan Gibson, will address whether New Hanover has standing, whether our complaint states a claim for relief under the new statute, whether the claim is justiciable. I'll deal with 2 or 3 issues. The first one to demonstrate that, in fact, we did raise the current constitutional questions in the courts below, despite contentions of the AG, which you just heard that we didn't, despite the dissent in the Court of Appeals from Judge Bryant, and actually in footnote 7 of this court's last opinion on this, saying we didn't raise it. We'll also talk about the purpose of Smithfield's gift of $50 million, why that matters, and why that controls who decides how to spend the money. When our brief was filed, our appellee's brief, there was $4 million in the state treasury that was post-2019 money. And by the way, we do agree with the Attorney General that the Court of Appeals was in error by, for whatever reason, roping in the pre-2019 money as well. And we've agreed with that since it was first stated. Since we filed our brief, it's now $6 million, but minus $1.2 million that the AG has somehow extracted from the Treasury by an inexplicable mechanism used through the Office of State Budget and Management. Since the law has been changed or clarified 3 times since we filed our suit. First, by the passage of this statute in November 18th, 2019. Second, by the first opinion in this case. We'll call that a clarification. And third, by Cooper v. Berger, which came more recently, and clarified that only the General Assembly appropriates money. Executive agencies don't get to do that. First, on that question of whether or not we raised this question, that, as I say, was raised in footnote 7 of the prior opinion. In our brief to the trial court, and it's at your record 205 through 207, we raised it 3 pages worth about such articles as Article 1, Section 6, Article 5, Section 7. It's all there. We raised it. We discussed it with the trial judge, Judge Ridgway, and that's in the transcript in the trial court at page 35, 36, and also 46. And I don't know why they say we never raised these questions in the court below. Judge Bryant said about I'm not sure what page numbers y'all use in that I should refer to, but it's like the 4th full paragraph from the bottom, quoting a case that say you got to raise it in the court below. Given that the board has not yet raised this issue before the trial court, it is clear that the issue of Section 5.7, that's a new statute, was not a suitable, quote, additional proceeding as expressed by the Supreme Court mandate. But we did. Now, if I could turn to the second question, what is the purpose of Smithfield's grant? This court has held, as the Attorney General asked you to hold, that $50 million was a gift, what we would say a free will offering. Some places they distinguish between tithes and free will offerings. This was just out of the goodness of their heart to get favorable publicity around the state. As a result, they needed favorable publicity because they'd gotten a whole lot of bad publicity before that. If New Hanover prevails and the General Assembly then appropriates the funds to the public schools for environmental enhancement at the public schools of North Carolina, then Smithfield's purpose is intact. Perhaps more so, since education is far more popular than fixing an abandoned lagoon or protecting wildlife habitat in some remote place in the mountains. But whatever you think of that, they still get their purpose to burnish their image. On the other hand, if the Attorney General wins, then it's only the Attorney General's image that is burnished, enhanced by distributing other people's money to favored grantees. By arguing for his position to control this money, the Attorney General undercuts his own position that this was a free will offering.
Could I ask you a procedural question? I'm trying to understand why, in the first instance, the Court of Appeals believed that it should address what could arguably be an amendment to the complaint, as opposed to allowing that to go back to the trial court to let the trial court determine is the relief currently sought the same as or similar to what was in the original complaint. Was that even discussed at the COA, or help me understand?
There wasn't an oral argument at the COA, but I would answer it briefly, and Mr. Gibson is going to discuss it at much greater length. There are no new facts that we would have found at the trial court. The new theories had been raised at the trial court. This court's mandate told the Court of Appeals to whatever additional proceedings, and there were no new facts to be found or admitted. It was just a trip down and back to no purpose.
So let's assume that there is a procedural debate, as it certainly appears to be. Why shouldn't procedural questions, in effect, does the complaint need to be amended? If so, would that be allowed in this case? Why would that not be better decided by a trial court in the first instance?
Well, there are no new facts to be found. All the facts that control are in the record. And all you're doing is applying a new statute, a new case law, Berger and the court's opinion in this one, to the extant facts. And this court has said many times you're not bound by your prayer for relief, you're not bound by your theory, you're bound by the facts.
But to follow up on the Chief Justice's question a second, and if you prefer that I defer to Mr. Gibson, I'll be happy to. Feel free to do that if you'd like. Pretty clearly, the claim that was asserted in the original complaint referred to the penalties clause.
Sure.
It cited more. It specifically referred to that. You and I had a discussion about it when the case was last here, I believe.
Right.
And can you point me to any decision that says, in effect, when something is sent back to the Court of Appeals, that a claim under a new statute, even if there were allusions to it allusions to the subject matter in the original complaint, was allowed on appeal as compared to in the trial court, as the Chief's question suggests?
Justice Irvin, I'll let Mr. Gibson answer that at great length.
I invited you to do that, and you're welcome to.
I would just say the court's footnote 8 encouraged them to do it, and any other, I'll just leave it at that.
Okay.
Okay.
That's fair.
And nothing would have been accomplished by that except more delay, and as you know, this is now 5 years this case has been moving, and there's been no delay on anybody's part. It's just, it takes a long time to go up and down the appellate ladder. Okay. The statute is on page 5 and 6 in our brief. You probably have it right in front of you. And subsection A is real clear, and this court was real clear, that this is a gift. The Smithfield money is a gift. So the statute applies. Subsection B, the AG agrees and has deposited the new $6 million in the Treasury. That's not a difference between us. And it doesn't, nothing in this section part says that is, the Attorney General's bound by it. Section C is the interpretation question. Except as otherwise provided by Section B of this section. Now, I'm going to come to another problem, but that one right there defeats the Attorney General's argument, because what is subsection B of this section? Put it in the Treasury. What has this court said about appropriations, money taken from the Treasury? What does the Constitution say about it? The executive branch can't do it. The legislature has to do it.
Can the legislature authorize an executive branch agency to spend money?
Yes, yes, but that has not happened in this case. And none of that money has been appropriated as of the date we filed.
Is your definition of appropriated that it has to be in an annual budget bill?
No, it doesn't have to be in an annual budget bill, but it has to say the General Assembly enacts, and it is hereby appropriated to whomever. So
if the General Assembly passes a bill that authorizes the expenditure of money, but it doesn't use the word appropriate, it then hasn't appropriated the fund?
if it had some synonym for appropriated, that'd probably be okay.
Okay.
But there hasn't been anything done that's a synonym to appropriated. It's not been appropriated. So I think the resolution of this case stops right there. But when you go, if you want to find a second reason, you go down to the, which the term to supersede, authorize a deviation from the terms of an instrument. Now, what kind of instrument are we talking about? Well, one's evidencing a gift or donation. That's just telling what it is. But setting forth the purpose. Well, the clear purpose of this gift is environmental enhancement. It's not the clear purpose to give it to the Attorney General to pick and choose where it'll go. And our proposed relief is that it goes for an environmental enhancement at public schools. And the reason it should be at public schools is because of the other constitutional provisions which we've cited that says money that was not appropriated goes to this fund from which it can only be appropriated to the public schools.
So then, is it your position that gifts can only be given to the state if they go to public schools?
No, Your Honor. There's carve-outs. I had some statutes here. For example, University of North Carolina, you can leave your fortune to the University of North Carolina. And there are many other, there are lots of institutions that you can give it to. But if it goes into the Treasury and is not otherwise appropriated, it can only go as appropriated. That's what the Constitution says. That's what Cooper v. Berger v. I'm sorry. I kind of remember which is which, Cooper v. Berger. That's what Cooper v. Berger says. And that's a recent case. But inexplicably, and I'll just take 1 minute of this, and this is not a fact that was pled in the complaint or a transaction or occurrence, but it's before you, the Attorney General has been taking that money out of the Treasury. The last I found out from OSBM, they'd already taken $1.2 million, which explains why in their early brief they said, well, it doesn't matter who wins because we're going to keep doing what we did anyway. I thought that meant that as to the money that was pre-2019, that they would keep doing what they would do, and I agreed with that. But the idea that anybody, I thought the Treasury was like Fort Knox, and you had to have a key to get in, and the key was the appropriation bill. But apparently, OSBM and the Attorney General have figured out another way in.
Yes. Before you sit down, just one more quick question.
Yes.
So with your example, somebody gives their estate to UNC Chapel Hill. Does there have to be an appropriation from the General Assembly to effectuate that gift, or does it go to UNC Chapel Hill?
It goes to UNC Chapel Hill, and I had a statute written down, and maybe Mr. Gibson knows it because he showed it to me. Okay. And there are lots of other ones that you can give money to.
And if your honors would like, we can certainly provide that statute in a memorandum of additional authority. I'd like to pick up with the procedural posture at the Court of Appeals, because I think that is one of the more interesting aspects of this case. And I apologize for not introducing myself. A little too excited here. I'm Dan Gibson. I'm a partner at Stein Law Firm, and I represent New Hanover County. So at the North Carolina Supreme Court, the day before oral argument, General Statute 147-76.1 became law. And at roughly 4 o'clock in the afternoon, the day before oral argument, we filed a memorandum of additional authority to this court, letting this court know that we would address it at oral argument. We made arguments based on the statute. The Attorney General essentially took no position on the statute because really nobody had had the time to read it. In fact, I think, Justice Urban, you might have even said that at oral argument. This court then issued an opinion, and in footnote 8, the court's opinion said the parties agreed that that statute had no applicability to this case.
Well, it said that the parties agree that it will not have the effect of mooting the appeal.
I'm getting there.
Okay.
We filed a petition for rehearing to this court, and footnote 8 was amended to include that language.
And as always, I appreciate being given additional insight when the time comes.
And that footnote was also the footnote that included a mandate to the Court of Appeals to take further proceedings not inconsistent with this opinion. And I don't think that was accidental on this court's part. I think specifically addressing that statute and then saying further proceedings not inconsistent invites the question of some clarification as to what effect, if any, this statute will have. The only opinion that this court had was that it didn't moot the case.
And we went on to say, as a result, and this is, I'm reading hopefully reading the correct version. I was concerned that I might not be. As a result, we will refrain from attempting to construe the statute or to apply its provisions to the facts of this case. We express no opinion what effect, if any, the statute has on the agreement or on any past or future payments hereof. Now, Mr. Stein suggested that that was an invitation on our part for further proceedings before the Court of Appeals without regard to the normal procedural rules that apply. Is that your argument? And if so, tell me more.
Our argument is that invites the Court of Appeals to determine whether or not this statute is applicable to this case.
And how do you get that, Mr. Gibson, when it simply says remand for further proceedings not inconsistent with the opinion, and we don't take a position on what this statute means?
I think the court's silence on that statute and the parties raising the issue of that statute certainly suggests that it's an open question in front of the court.
Right, but I mean, there are normally rules of procedure that are followed. Is it your contention that this footnote somehow authorized different proceedings than normal?
No, certainly not, Your Honor. We would argue, and amicus Marcus Gadsden from the Campbell University School of Law has argued that the proper typical procedures have been followed here.
Can you name me, can you cite me another case where essentially a case went up to an appellate, was litigated on one theory, it comes back down to an intermediate appellate court, and instead, as the Chief Justice's earlier questions alluded to, instead of it being remanded to the trial court, and the trial court being asked to consider whether an amendment to a complaint was appropriate, instead what happened here was done in the intermediate appellate court.
I think the closest case on that issue is Enoch versus Inman. We cited that case in our briefing, and I'll tell Your Honors, I looked at the record in that case, and it is a pleasurably short record. I think it's only about 24 pages, give or take. The plaintiff in that case pled a direct constitutional claim. Now, I think most of us learned in law school.
Is that the case in which there was an argument over whether a direct constitutional claim and a 1983 claim were?
That's correct. And the defendant moved to dismiss. There was no mention of 1983 in the complaint anywhere else in the record. And the Court of Appeals, despite the statute not mentioning 1983, and as far as I can tell, despite 1983 not being argued below, held that factual allegations that were sufficient to allege that a constitutional right had been violated were sufficient to state a claim under Section 1983.
Is it 1983 the way you assert a constitutional claim for the most part against a governmental official?
That is correct.
And your contention is that that situation is analogous to this one?
Well, my contention here, Your Honor, is that the key principle here with complaints, especially under notice pleading, is that the purpose of the complaint is, as Rule 8 says, to give notice of the transactions or occurrences. Complaint, as Enoch and Standback both mentioned, the key to the complaint is the factual allegations, not the legal labels. Mislabeled claims don't particularly bar you from pursuing. So the question here is, when we look at the pleadings as stated in the complaint, and we look at them in light of in all favorable inferences taken towards the plaintiff, does it state a claim under this statute?
I'll let you get to your argument, but got one more question. Do you agree with Professor Gadsden that it's not necessary to allege all the elements of a cause of action to state a claim?
I don't think that's the position that Mr. Gadsden is taking. I think that's something of a misstatement of his position. I realize I'm standing here accusing opposing counsel of misstating Mr. Gadsden's position, but
I mean, if you need to do it, you need to do it.
I think what's necessary is for you to give factual allegations that put the defendant on notice of your legal theory. So the way that I would analogize this case most closely is, let's say you have a plaintiff who files a breach of contract case against a defendant. Says, you signed a contract with me, I was going to pay you $2 million, and you were going to do this work for me. You didn't do the work for me, you owe me $2 million. Well, the defendant files an answer and says, no, we never had any contract. You can't win against me on breach of contract. Well, they win on summary judgment in the trial court. Trial court says there was no contract. Court of Appeals says, well, actually, there was a contract. It goes to the North Carolina Supreme Court. The North Carolina Supreme Court says, no, there was no contract. That plaintiff can then say, well, hold on, even if there was no contract, you were still unjustly enriched, and my complaint puts you on notice of facts sufficient to allege unjust enrichment. I paid you $2 million for services. You knew you weren't getting the $2 million for free. You didn't perform the services for me. I would like my $2 million back, please and thank you. And that's essentially what we alleged here. If you look at the complaint itself, we allege, and the Attorney General admitted earlier, that the Attorney General is receiving money. The complaint then goes on to allege that the Attorney General is distributing money. The Attorney General still agrees that he's distributing money. Now, there's a key logical inference there, which is that the Attorney General isn't first placing that money in the Treasury and it's not going through the proper General Assembly appropriation process. That's a logical inference you can make from our complaint, and Professor Gadsden accurately describes that position and argues well from that in his brief. I would like to point out, for the record here, in Attorney General's brief at page 22, he says, amicus candidly recognizes that the allegation that the Attorney General distributed funds leaves room for the possibility the Attorney General did put money into the Treasury before distributing it. And that's quoting amicus brief at page 5. But the sentence at amicus brief at page 5 says, even if the court thinks the allegation leaves room for the possibility the Attorney General did put money into the Treasury before distributing it, the court should interpret any ambiguity in the board's favor. So this is essentially an argument saying, if you think the complaint is ambiguous, you still have to resolve ambiguities in favor of the plaintiff because of the failure to state a claim standard here that we're arguing. I think that's very important. The Attorney General spends some time in his reply brief arguing that the no set of facts standard should apply here. We think that the Attorney General there is sort of trying to have his cake and eat it too. If we're arguing whether or not the complaint states a claim, then the no set of facts standard should apply and we should only look at the pleadings. If we're not going to apply the no set of facts standard, then we should certainly look beyond the pleadings if this is summary judgment review. And if you do that, you find things like record page 110, which is an affidavit from the Attorney General describing the distribution process that the Attorney General's office is doing here, which is sufficient evidence to say that this money is not being properly appropriated through the state treasury issue. One of the Attorney General's arguments there is that the issue of whether or not money that's made it into the Treasury can later be controlled or distributed by the Attorney General is not properly before this court. I think that's just wrong on the procedural history of this case. The Attorney General filed a petition for discretionary review. We argued the court shouldn't grant discretionary review, but we included additional issues in response to the petition for discretionary review. Issue 4 in our response was, do the terms of the Smithfield Agreement and North Carolina General Statute 147-76.1 allow the Attorney General to control the disposition or appropriation of funds received under the Smithfield Agreement and deposited into the state treasury? The Attorney General, or not the Attorney General, this court granted that petition for discretionary review on April 14th, 2021. So that issue
Is it your contention that the issue that you just described was decided by the Court of Appeals?
I don't believe it was, Your Honor. I think they may have mentioned it. That's one of the reasons why we included it as an additional issue in a petition for discretionary review. I think that's one of the purposes for a petition for discretionary review, especially when you're appealing from a dissent at the Court of Appeals. Typically, you're limited just to issues that are in the dissent. So I know the Attorney General raised several issues in their petition for discretionary review. We did as well. I'd like to just briefly visit the standing issue. I realize I'm running short on time. The Attorney General has repeatedly challenged us, saying that we cannot cite a statute that gives us standing. And that may be true when it comes to a statute that expressly gives standing. But there is precedent that a statute need not expressly give standing. It can implicitly give standing. A case that the Attorney General cites, Sykes v. Solus Health Systems, and a case that we provided in our Memorandum of Additional Authority to this court, Sugar Creek, both directly deal with implied causes of action in statutes. And I think Sugar Creek is very instructive because it describes essentially the facts of this case. It says, an implicit right of a cause of action exists when a statute requires an action from a party and that party has failed to comply with the statutory mandate. We have a right under 147-76.1 and Article 9 of the North Carolina Constitution to a portion of the funds here.
So is it your contention that anybody who can construct a claim to funds has a right to bring an action under 147-76.1? Hopefully I got that somewhere close to right.
I think you got your statutory site correct, Your Honor. My contention is if a statute or the Constitution or the common law entitle you to funds from a party and that party doesn't give you the funds, you have the right to sue them. That's the core of our remedy clause. Dan Forrest and the remedy clause don't say anything more, in my opinion, than there is no right without a remedy. That's old common law. That's as old as the common law is. If a statute says the Attorney General has to put this money in the Treasury, and the Constitution says once it's in the Treasury, unless it's appropriated, it goes to you, which is exactly the case here, and you're not receiving the money, you have the right to sue the Attorney General and say, stop giving this money to people that aren't me.
So if one was to conclude that you had a valid claim, then you have standing, and if one concluded that you didn't have a valid claim, you don't?
I'm sorry, could you repeat?
I'll try. So are you merging standing and the issue of whether you have a valid substantive claim?
I think those issues do somewhat blend together. Because if we're arguing that the statute here is one of the things that gives us standing, if we don't state a claim under the statute that could imperil our standing argument, realize I have very little time here. I'd like to just briefly address the mootness issue while I have less than a minute here. I think our best argument on mootness is the public interest exception here. And the reason why I think that's a great argument is that the Attorney General's only response to that argument is, well, those issues aren't properly before the court. But as I explained earlier, when this court granted our petition for discretionary review, it placed those issues squarely in front of this court. If this court didn't want to review them, they didn't have to. If the court didn't think we properly preserved them, it could have denied our petition for discretionary review, but it granted the petition for discretionary review, and we expressly argued in our petition for discretionary review that this court should decide, once money is in the Treasury, can the Attorney General control or appropriate that money? And we think this court should decide that issue. Thank you, Your Honors.
Thank you, counsel. Rebuttal?
I'll try to be very brief, Your Honors. First, I'd just like to address preservation, because it's not an issue that I addressed during my opening argument. So first, Mr. Gibson here has argued that when this court grants a PDR, that automatically solves any preservation issues that might exist. That's not correct. In our brief, we cited a decision from this court called Piazza, where this court held that preservation issues are inherently intertwined with any issue on which a PDR is granted. So just because a PDR was granted, that doesn't mean that preservation issues go away. Second point I'd like to make is, again, these new claims they're asserting with respect to how funds are used once they're deposited are not preserved because they weren't asserted in the Court of Appeals. If you take a look at their supplemental brief in the Court of Appeals on page 4, on page 9, on page 12, and on page 12 again, they again say again and again that the relief they sought was the deposit of funds into the Treasury, not any claims about how they were used following that deposit. And then finally, in the trial court, my colleague Mr. Stein here argued that they raised these claims in the Court of Appeal, in the trial court, but that's just not correct. Actually, the trial court asked Mr. Stein during the summary judgment hearing, are you asserting any other claims other than your civil penalty claim? And he said, well, we agree some of these issues are floating around here, but, and I'm quoting, this is on page 36 of the transcript, but the constitutional provision before you is Article 9, Section 7, where it should go, the civil penalty claim. So already in the trial court, they disclaimed any intention to assert additional claims other than their civil penalty claim. And the final point I'd like to make is just Mr. Gibson briefly argued that they have an argument that they have standing because the 2019 statute creates an implied right of action. They did not make that argument in their response brief, so the argument has been waived. And while that may be an interesting question for another day, it's not one for the court right now because we've not had an opportunity to brief it. So unless there are any further questions, we would respectfully request that this court reverse and vacate the decision of the Court of Appeals and remand this case for summary judgment to be reinstated for the Attorney General. And I'd just like to say, well, it's wonderful to be back here in person with all of you today.
Thank you, counsel. Thank you to all counsel. Madam Clerk?
Yeah, good job, y'all. I'm the circuit, you were babysitter.